Hello, we're here with Marshall Ferguson, who is running for Superior Court Judge position number 31. If you'd like to take 2 minutes for an introduction.
Yes, good evening to everyone. My name is Marshall Ferguson. I'm a King County Superior Court Judge, position 31. Governor Inslee appointed me in July of last year, so I've been doing this for about 10 months as a Superior Court Judge. I've been rated exceptionally well qualified by the King County Bar Association and either exceptionally well qualified or well qualified by assorted minority bar associations. I'm still in the process of getting evaluation ratings. Before I was appointed to the judiciary, I was in private practice for 19 years. I was a partner at the law firm of Williams, Castner & Gibbs. It's a downtown firm of about 100 lawyers. I became a partner there in 2012, and my practice consisted primarily of aviation and real estate related commercial litigation in state courts and in federal courts through the state courts of appeal and Ninth Circuit Court of Appeals, but also trial courts. I was the firm's chief ethics officer. I was a state bar disciplinary hearing officer. I pro-tend at the Edmonds Municipal Court. I have lived in Seattle since 1996. I've lived in Washington since '89. My hometown is Locust Island, Washington, up in the Santa Monica. And I decided to seek employment in the judiciary because even though I don't think that justice is a zero-sum commodity, I felt, especially in recent years, that the world needed a little bit more of it, and that my legal acumen, such as it is, could be of service to the people of King County. Thank you.
Thank you. Let's see here, I think we're on 4.
How would you describe your judicial philosophy?
Well, right now I am in the criminal department in the King County Superior Court, and my judicial philosophy is centered around what I call the 3 R's: rehabilitation, restorative justice, and redemption. And what I mean by that is that I believe that judges can and should make a long-term investment in folks who come before the court, especially in criminal matters. In most cases, we are not sentencing people to life terms in confinement. They're going to be out in the community again someday, even if they're sentenced to lengthy jail terms. So generally, I want to put people in the best position possible to make sure that they are not going to reoffend. And that means engaging with their families, with their employers that they have, with treatment centers, with whatever resource can be useful to that person to give them, again, the best shot at success of not reoffending. And it sounds corny, but I also believe that redemption is possible in many, not all cases, but in many criminal cases. And I think that is something that can be useful not only to offenders, but to crime victims as well. And then of course, restorative justice is not just an abstract concept to me. It is something that I've seen be successful in criminal matters again and again. And again, where it's appropriate, it's something that I try to incorporate into the cases that come before.
Thank you. Elizabeth, can you read question number 2?
We got one, I'm gonna pass. You wanna pass? You want me to read one?
I would love for you to read.
Okay. In the area of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity?
Well, certainly hate crimes are a special kind of assault because in addition to the physical act of assault, there is incorporated within a hate crime an attack on some immutable characteristic of the person, whether it's race or sexual orientation or gender or what have you. Of course, as you noted, there are potentially First Amendment implications when an offender, as part of the assault, makes statements or maybe has a history of posting things online that are racist, sexist, or offensive in any variety of ways. The risk, of course, is that you are punishing people for their thoughts, for their expressions, rather than for the crime charge. I personally think that hate crimes are a special species of assault, and there is a legal basis for prosecuting them as a separate type of crime. But of course, in every case, the circumstances will have to be very thoroughly examined from a legal perspective to make sure that defendants are not being punished for offensive views or thoughts.
How would/do you deal with a pro se party appearing in your court?
Well, there are a variety of ways to deal with pro se parties. Plenty of people come to court pro se and they are well prepared. They are, you can hold them to the standard of an attorney and they will live up to it. But of course, most people who are pro se come to court without any legal training or background. They're unfamiliar with the procedures or rules. As a judge, I can't tilt the scales in their favor necessarily, and I can't give them legal advice. On the other hand, I will not, generally speaking, will not let the other side take advantage of them if the other side is represented by an attorney. So oftentimes it's a matter of setting their expectations about what can be accomplished during the proceeding. If they are heading down a road that is obviously not going to serve their objectives or may just run afoul of the court's procedures, it might be appropriate to take time out to suggest that they confer with an attorney, maybe consult with King County Bar Association's referral service if they really get in hot water. In criminal matters or in mental health court matters, folks, of course, have an absolute right to defend themselves, but generally we're going to go through a colloquy to make sure that they understand what they're giving up if they're going to represent themselves. So that is a knowing, intelligent, and voluntary waiver of their right to counsel. And again, you might appoint standby counsel in a criminal matter. You might potentially appoint standby counsel in a mental health matter. But there frankly have been times where I would let people go pro se, and then they get halfway through their case, realize that they need an attorney, and in certain circumstances, I'll let people revoke their waiver and proceed again with an attorney, but that would be unusual.
Thank you. Ben?
Like the rest of the government, the courts have struggled with reduction in funding. Where can the courts cut costs and increase efficiency, and how will you advocate for sufficient funding of our judicial grants?
There should be no further cutting of costs in the judicial system, in the judicial branch. I really think that from an efficiency standpoint, all of the efficiencies have been worked out. There may be minor tweaks or adjustments that could be made, but we've cut things like court reporters. We have been cutting back on interpreters, although the interpreter funding is going to be part of the budget this time around. I really don't think there are any more efficiency-based cuts that could be made in the judiciary. Before the budget was passed, there was a push for more funding for interpreter services. My understanding is that is going to be a part of the budget. It was fully funded at $2.1 million, which I'm incredibly happy for. That's an incredibly important component of what we do. So going forward, I'm not sure what the next point of emphasis will be. That's something that the judges have really gotten behind in the last session. But if anything going forward, I would push for more judicial officers, more commissioners. Those are things we've had to cut back on recently. The population of King County has grown in the last decade, and the population of judicial officers has not grown in commensurate fashion. So more commissioners, potentially more judges, and over the long term, my priority would be to push for a new downtown King County courthouse. But a lot of money was put into restoring the courthouse, I believe in the 90s, so I don't know that it's going to be financially plausible in the near term, but in the long term, I think we need a new courthouse building downtown.
Thank you.
All right, follow-up questions with 1-minute responses. Does anybody have any they'd like to ask? Yeah.
Yes. Do you
have a particular Supreme Court justice, past or current, U.S. or otherwise, that you look up to or you see as a hero or someone you want to emulate?
Justice, the ones that leap to mind would be Justice Cardozo, Oliver Wendell Holmes. For all of his shortcomings, he's a very brilliant man. Justice Berger, some of the justices who were involved with Watergate and the Nixon proceedings, they had to really wrestle with some incredible constitutional crises. Certainly Thurgood Marshall, who as an attorney had some incredible accomplishments during the Civil Rights era, and also, of course, as a Supreme Court justice, being the first African American Supreme Court justice. Those are the folks who look to mind.
I have a question. Can you please describe your most difficult case?
As a judge or as a lawyer?
Your choice.
Sure. I think of a couple, actually. Most recently, I had a sentencing in a murder case where the offender was 16 years old at the time of the murder. It's not a case where I can get into the facts because it potentially could be appealed. But that sentencing was difficult on a number of levels because of the age of the offender, the age of the victim, and because I had a great deal of discretion, I wrestled with what would be the most just outcome for the community, for the victim and the victim's family, but also for the offender who had trauma in her own life, in her own past. As an attorney, I had a case early on in my career where I represented a woman who found a little lost puppy. It was a little lost puppy case. She found a purebred, it was a beagle. It turned out that the beagle belonged to a neighbor, but she.
You want him to continue?
Yeah.
Dog case. It was a dog custody case. So my client found a puppy, nursed it back to health, and at the time my client had cancer. So my client and this dog kind of went on this journey together. She beat cancer and she nursed the dog back to health, and the dog helped her through her cancer treatment. Well, one of the neighbors drove by and said, "That's my dog, here's the pictures, I can prove it." And to dissuade the neighbor from taking the dog back, my client had the dog spayed. And because she knew that the neighbor wanted to breed the dog. And so the neighbor sued my client and ultimately got the dog back. My client's position was not defensible in some ways. But my main concern in the case was that she had a cancer diagnosis, she'd been having trouble with her adult daughter, and I thought this was just going to be emotionally devastating for her. But what happened was, because she had her day in court, and because she was heard by the judge and her attorneys helped her put on her case, when the judge was bench trial, when the judge made the ruling that she had to surrender the dog and pay some damages, it wasn't devastating, again, because she was hurt. She had her day in court, and I lost a lot of sleep about that case. I was worried that she would be crushed by it, but I mean, it was a good illustration for me that there are a lot of folks out there who can live with an outcome, even if they lose, provided that they've had their day in court and they were hurt.
What is your position on a defendant's ability to pay court fees and fines?
Well, of course, we're required to inquire with defendants about their ability to pay. Most of the cases that I handle where I do sentencing involve indigent defendants, and in almost all of the cases, I am waiving non-mandatory legal financial obligations. So what that ends up looking like is a statutorily mandatory $500 victim penalty assessment, and then if DNA is collected, there's a statutorily mandatory $100 fee that I don't have discretion to waive. Everything else gets waived. In certain circumstances, there might be folks who admit to the court, I can afford to pay something more than this. So we delve into an inquiry about how much they can afford, whether, you know, what if you lose your job in 6 months because now you've got a conviction and you're kind of planning for that, and then how they're going to pay, you know, monthly payments or lump sums or what have you. So I think it's critical that we ask those sorts of questions.
Thank you. Any other questions?
Yes, ma'am.
Judge Ferguson, we have all been working very hard on gender equity, and in particular, women who are particularly vulnerable have been victims of psychological and physical abuse and domestic abuse. And so I've started asking judges, can you say, I believe women?
Yes. I hesitate because I can say, it's one thing for me to say, I've read something in the New York Times and I believe the accusation or the allegation. It's a different thing for me to say as a judge that if I'm going to be the fact finder in a case, that I'm going to assume in each and every case that a woman who is making an accusation about a sexual assault or sexual harassment is credible in each and every case. Again, as a judge, I have to evaluate the evidence that's presented to the court, again, if I'm the fact finder. And I'm going to evaluate things like a person's credibility, whether the story is factually consistent, whether it's corroborated in some way or not. Certainly corroboration in some cases is not required. You can, for example, reach a conviction in a rape case, even if there's no corroboration of the victim's story. But the answer is, in legal cases, it's different.
Thank you.
Yeah.
Sure. We have a couple minutes.
Because getting back to domestic violence and psychological violence, psychological abuse, would you say that it's very important for a judge giving instruction and help to a pro se litigant, I guess, that you get the process right? Because if, for example, a defendant wants to counterfile, there's a victim who's going to be very impacted, right, by that process. And so thus my asking you again about a depth of understanding of psychological violence and domestic violence, particularly against women, and their positions as victims, as the pro se defendant may be asking for ways to work around.
Right. Well, I can tell you, in my experience dealing with victims of domestic violence, it is not uncommon for women to, in some ways, go to bat for their attacker. And an example would be if there's a no contact order issued. What we'll see sometimes is 6 months later, or a year later, they'll petition to have that NCO lifted. And I often come at that with a bit of skepticism, because my concern is that they're being pressured by their attacker to have the no contact order lifted because the attacker wants to see his child or something like that. There's always the risk that there's some psychological manipulation of the victim in order to get the victim to do something that is contrary to her interests. Is that what you were
No, that is not relevant to psychological abuse or domestic violence. What I'm asking about is different. So perhaps we could talk offline.
Sure.
Thank you. And just in this room, can you say, I believe women?
I do believe them. Absolutely.
Any other questions? All right, well, we've got about a minute left, so, Kelly.
I grew up 30 miles from the Supreme Court. When I was in school, the board came down, which had zero consequence on the way our educational system was organized, at least for 7 years. But anyway, I just thought I would inquire what your view of Brown v. Board of Education is at this moment, after all this time.
I guess, are you asking my view of the legal opinion or kind of the legacy of attempts at desegregating?
So where do we stand at this moment with respect to a transcendently important legal decision by the Supreme Court of the United States many years ago? Where do you think we stand with respect to the implementation of that legal opinion?
I think, first of all, we're seeing a backlash, a generalized backlash to the civil rights gains of the last 60 to 70 years by at least a third of the country, maybe half the country. We've seen attacks on the Voting Rights Act, attacks on voting, basically just voting in general, but we've seen a lot of voter suppression efforts. And with regard to Brown, it has been discouraging for me to see that although I believe the country has made strides in the area of desegregation, certainly de jure segregation, that there have been both formal and informal attempts at resegregating schools on a de facto basis all over the country. And there have even been just forms of social segregation that again are incredibly discouraging to me.
We have time. Do we have time?
Actually, we are out of time, so maybe you guys can talk about that a little later.
Sure.
If you would like to give like 30-second wrap up, we can.
All right. Well, again, I am honored and privileged to have been appointed to position 31 in King County Superior Court. It is endlessly gratifying to me to be a part of a system that administers justice in King County, to be a part of the criminal justice system, but also to take part in things like mental health court and adjudicating civil matters. I am just frankly proudly amazed to be able to participate in the system, and I'd be honored to have your endorsement.
Thank you.
Thank you.